Hello again, I'm Myrtha, and in this video, I want to talk about 7 other options to avoid probate if you don't want to set up a trust. A trust is the best way to avoid probate for most people, but maybe one of these 7 other options will work for you in your special situation. All right, before I start, let's talk a little bit about probate, okay? Probate has a bad reputation, but its intention is actually to protect you from fraud. See, probate happens when I die and my assets are still in my name. I'm not around anymore to sign off on the titles of the assets. So the court steps in to prevent fraud. The court wants to make sure that my assets go to the right heirs. Because, once again, I'm no longer alive, no longer around to sign off on those titles. It's just that anytime the court steps in, things get dragged out. It's a public affair. That's why, by the way, you can go to Carver County, Minnesota today and look up the assets of Prince, the musician. Here's a recent article from Forbes, and it estimates that it takes about 20 months to wrap up, and it costs between 3% to 7%. So, for example, if your estate is a nice round number of $1 million and you had a really smooth probate, everything went your way, and it only cost you 3%, that's $30,000. That's a lot of money. The way to avoid probate is to make sure that when I die, my assets are no longer in my name. These 7 different options to avoid probate, they're all trying to make sure that my assets are no longer in my name when I die. Option number 1 is to give your assets away. Once you give your house away, for example, to your kids, the house is no longer in your name, so you've escaped probate. But this plan is a bad one for most people. Why? Number 1, loss of control. Once you give your house away, even if your kids allow you to live in the house, you can no longer sell it, rent it out, refinance your house because it no longer belongs to you. And secondly, you miss out on this big tax benefit called a step up in cost basis. Look up the video, the in-depth video about this in the description below. Gifting something away is considered a change in ownership that will trigger a reassessment, which may result in higher real estate taxes for the same house. Option number 2 is to have a joint tenant with rights of survivorship. Then when I die, the asset automatically goes to the joint tenant, no probate. This is actually a very popular strategy that a lot of Chinese families use because we tend to be cheap. Instead of paying for a trust, we think that doing it this way costs a lot less and accomplishes the same purpose. Yes, it accomplishes the purpose of skipping probate because your house automatically goes to your child if you put your child as a joint tenant. However, there are other negative consequences that you should definitely know about. One is that if you put your child as a joint tenant of your house, you can no longer sell the house, refinance the house without the consent of the other joint tenant. But more importantly, if your child is a legal owner of your house, which is what a joint tenant is, right? He owns half the house. Then your house is now vulnerable to your child's financial risk. If your child is in a lawsuit, car accident, creditors, or a bankruptcy, or if your child is in a divorce and he had commingled his property with his spouse, then your house becomes vulnerable to all his financial bad luck. Option number 3 is to name beneficiaries to the assets. you call the financial institution and ask them for a form where you can name specific beneficiaries that will inherit the asset after you die. No probate, no court process. It's very straightforward. Not all assets allow you to name beneficiaries this way. You must make sure the beneficiary you name is not a minor. When I die, the asset is given to the beneficiary outright in one lump sum. I don't think my son is ready for that. And what if you have a child with special needs? Him just inheriting money outright like that will disqualify him from the government benefits that he's getting. Option number 4, some states actually do allow you to record a transfer on death deed on your real estate property. The transfer on death deeds for houses is only available in certain states, and you want to make sure that it's a situation where the house has been fully paid off and you are naming only one beneficiary on the transfer on death deed of the house. All right, option number 5 is to set up an LLC, which is a limited liability company, or an S corporation to shield your property or your assets. Then you could set up operating agreements in the companies to state that if one member passes away, the rights of ownership to the asset will pass to other members of the corporation. This way you're avoiding probate, because when you die, there's already a plan for the asset to be transferred to other owners of the corporation. But if you transfer this house to an LLC or an S corporation, then the home sale exclusion no longer applies, because that's only for individuals, not for corporation. So if you end up selling the property under the corporation, you'll have to pay tax on the entire capital gains, no more exclusion. Also, if some of you do a home state protection, that protects your home from creditors, lawsuits, etc. That's also only available for individuals, not corporations, so you lose that protection as well. Remember, all these options, all it's trying to do is to get assets out of my name before I die, so I skip probate. Well, what's the easiest way to get assets out of my name? By giving it to charity, right? Then it is totally out of my ownership. But let's get a bit more sophisticated. Have you heard of the Charitable Life Estate? This is how it works. You donate your house to a qualified charity, but you can continue to live in the house. You do still pay for the expenses, the utilities, the real estate taxes, but you can live in the house as long as you want. And upon your death, the house will go to the charity. The downside for this option is that you cannot change your mind. You cannot change your mind about the charity that the house is going to. You cannot change your mind about selling the house or renting the house. You have to be sure that this is what you want to do, and you will not change your mind for the rest of your life. Option number 7 is for individuals who have a very small estate. And by very small, I mean very small for some states. For example, in Massachusetts, that small estate threshold is only $25,000. For California, that small estate threshold is $185,000. So find out what that small estate threshold is for your particular state. And if your assets is below that threshold, then you will skip the full-blown probate. It will still go through probate, but I call it a baby probate. You don't need attorneys. Most people do it themselves. But just remember, the threshold is quite low, so it's not going to work for most people. I did go through these 7 options pretty quickly because I've actually done an in-depth video on several of these options. If you're interested in a particular option, look for the in-depth video in the links that I will provide below, okay? By the way, what is your reason for not wanting to set up a trust? Is it because, one, you do not want to pay the high cost of estate plan attorneys, but at the same time, you don't feel confident doing it yourself, on these DIY online platforms? Because if that's your situation, I want to make sure you know about a third option. It's working with an advisor, like a certified estate planner like myself or a financial advisor, to do it with you. This model costs a lot less than hiring an estate plan attorney, but you get the one-on-one expert guidance of a certified estate planner. If you want to find out more about this option, I have a free webinar coming up. You can sign up for the free webinar at startestateplan.com. I will also provide the link below, okay? A trust is still, for most people, the best way to avoid probate.